Let me play this ad for you. It's from 1998, and it's from the makers of OxyContin.
Some patients may be afraid of taking opioids because they're perceived as too strong or addictive. But that is far from actual fact. Less than 1% of patients taking opioids actually become addicted.
Doesn't age very well, does it? Purdue Pharma aggressively pushed OxyContin, a very powerful painkiller, to family doctors, marketing it as non-addictive.
As a salesperson, you're trained to know that an objection is a buying signal. So if the doctor has an objection, then that gives you the opportunity to overcome that objection.
But this aggressive pitch for OxyContin helped drive a nationwide opioid epidemic in the United States, as well as here in Canada. According to the CDC, in the years after OxyContin hit the market, opioid-related deaths shot up. In about a 20-year period, more than 500,000 Americans died from opioid addiction, about a third of that from overdosing on prescription opioids. Twice, Purdue Pharma pleaded guilty to federal criminal charges for its deceptive marketing. Facing $40 trillion in lawsuits, the company filed for bankruptcy. And the family that owned and ran Purdue Pharma, the Sackler family, they made a deal.
They agreed to contribute several $billion into a settlement fund that would be paid out to creditors in return for being released from any current or future lawsuits over their role in creating the opioid epidemic.
This is where we are today, before the U.S. Supreme Court, because this legal deal, where as part of a corporate bankruptcy settlement, individual members of the Sackler family, which ran Purdue Pharma, they get immunity from all future opioid-related lawsuits. Critics call that a billionaire escape hatch, one that should be struck down by the Supreme Court. But supporters say it is a necessary part of the system when you have these mass injury claims. So let's explain how it all works. A big part of Purdue's bankruptcy settlement, approved in 2021, was getting the Sackler family to agree to hand over about $6 billion as part of the agreement. A small part of the overall cash went directly to victims and their families, but most of that money, about 90%, was for different levels of government, both state and municipal, to help cover the cost of opioid addiction treatment and prevention. In exchange for all of that and giving up ownership of the company, the Sacklers secured two main things. One, no member of the Sackler family had to personally declare bankruptcy, which gave them a great deal of protection from the downfall of the company they ran. And two, they negotiated a non-consensual third-party release, which is legal speak for immunity. It's called non-consensual because all of those people in the future who may one day consider suing the Sacklers, they don't get a say. They effectively forfeit the option. Even the bankruptcy judge at the time called it a bitter result.
So, fundamentally, the non-debtor releases here were abusive because they were not consensual. People didn't get a choice. It was basically the Sacklers' way or the highway.
That's Jonathan Lipson. He's a law professor. As you can see, he's arguing a pretty clear point of view here. He's actually advised a group of law professors who have made known to the Supreme Court that they don't think these kinds of immunity deals are fair. But what was the alternative? More legal fights, more lawyer fees, more risk of walking away from the whole exercise with nothing left for victims? In the end, 95% of creditors approved the plan, and some very, very large organizations watching from the outside approved as well. The U.S. Supreme Court is hearing arguments about whether this practice should be illegal. Those who say it's legal say it's also crucial, and they point to how often these deals lead to very large, very efficient settlements. So in exchange for immunity, what you get are significant sums to a common fund, maximizing the recovery for claimants and relieving them of the struggle to recover in piecemeal litigation. You just settle everything in one fell swoop. This argument, by the way, was given to the Supreme Court by a group that isn't even part of the case, the U.S. Conference of Catholic Bishops. In its brief, the Catholic bishops say these non-consensual third-party releases provide the only viable means for the Catholic Church to survive what would otherwise be decades of what they call mission-crippling litigation over sex abuse claims. The Boy Scouts of America agree. There would be devastating consequences for both victims and venerable nonprofit institutions. Most survivors of scouting-related abuse would get nothing, and scouting as an organization would likely be finished. The Boy Scouts declared bankruptcy in 2020 in the face of numerous sexual abuse lawsuits. 85% of voting survivors approved the plan. In exchange for individual immunity from future lawsuits, there was a trust with nearly $2.5 billion in cash for abuse survivors.
Why would any survivor of the opioid crisis or sexual assault or abuse ever vote for the release and exoneration, civil exoneration of folks who were involved with their harm? And in the first instance, it's because they have no choice.
Closure really is the big one. The ability to get money in the short term rather than having to go through decades of litigation. Cash today is always better than the hope of litigation down the road.
So if you're like, well, okay, I can get nothing, or I can get a little bit, maybe I'll take a little bit.
Proponents of these non-consensual third-party releases, they generally admit, yes, it's an imperfect solution, but this is an imperfect world. It is the Biden administration itself, the Justice Department overseeing bankruptcy cases, arguing that this practice is just wrong.
At the end of the day, this is really only about two things. It's about your right to a day in court and the ability to preserve your right to forgive people contractually, to not be forced to give up your right to a day in court.
Basically, the government is arguing the bankruptcy court is sort of overstepping its bounds, that it has no right to approve a release from liability, effectively eliminating any chance for a victim outside of the bankruptcy deal to seek damages. There's a reason you have class action lawsuits. Is bankruptcy court really the venue to resolve those disputes, or is it just a legal pathway for the rich to control the outcome, to buy their way out of their problems?
It's very easy to demonize the Sacklers because they're actual, individuals. And they're individuals who really held themselves out as highly virtuous because they made such a show of funding the arts and good works and what have you. And at the same time, there's pretty strong evidence that their company, through them, some of them, did truly terrible things.
In the case of Purdue Pharma, 3 of the Sackler brothers who bought Purdue and ultimately developed OxyContin, they were doctors. The extent to which they can avoid future liability in the interest of settling more quickly, getting at least some money where it's needed, legal experts say this could be the most important bankruptcy case in 30, 40 years. A decision is expected by next summer.